Ever received a credit card you didn't apply for and wondered if you're bound by its terms? What if you're suddenly in debt for 264,173.6? Can the bank do that? Subscribe to find out. This is the second case involving credit cards decided by the Philippine Supreme Court. The decision of the Supreme Court forms part as the law of the land. Let us study the decision and learn from the experience of our kababayan. Subscribe to receive more contents like this. This is the case entitled Spouses Rainier, Jose M. Yulo and Juliet L. Yulo versus Bank of the Philippine Islands, GR number 217044, January 16, 2019. In the city of Makati, Philippines, a couple, the Yulos, found themselves in a bewildering situation. The Bank of the Philippine Islands, BPI, had issued Rainier Yulo a pre-approved credit card without him filling out an application form. His wife, Juliet, also received a card as an extension. Initially, they enjoyed the convenience, regularly using the cards for various purchases. However, the tide turned in July 2008 when they started missing payments. By November, their debt had snowballed to a staggering 264,773.56 PHP. BPI demanded payment through letters, but the Yulos contested, admitting to using the cards but arguing they were never fully informed about the terms and conditions, especially regarding the hefty charges for non-payment. The case escalated through the courts, from the Metropolitan Trial Court to the Regional Trial Court, and finally to the Court of Appeals, which all sided with BPI, holding the Yulos accountable for the debt, plus additional charges. Not ready to give up, the Yulos took their fight to the Supreme Court. The crux of the matter was whether the Yulos could be bound by the credit card's terms and conditions, given that Rainier never explicitly agreed to them. The Supreme Court issued a landmark decision stating that without clear evidence of the client's consent to the terms and conditions, they could not be held to those standards, despite having used the credit card. As a result, the Supreme Court modified the previous rulings, significantly reducing the Yulos' financial burden to the principal amount they owed, excluding the compounded interest and penalties that had inflated their debt. They were ordered to pay 220,757.51 PHP, a sum based on their actual credit card usage, with a more reasonable interest rate applied. Dispositive portion of the Supreme Court decision. The Supreme Court directed the Yulo spouses to pay BPI P220,057.51 plus legal interest of 12% per annum from November 11, 2008 until June 30, 2013 and 6% per annum from July 1, 2013 until fully paid. The award for attorney's fees was deleted. Important doctrines discussed consent in contractual agreements. For a contract to bind the parties, there must be consent, which should be proven by the party alleging it, especially in cases involving pre-approved credit cards where explicit consent to terms and conditions is not evident. Liability for use of credit cards. The use of a credit card constitutes acceptance of a contractual relationship, making the cardholder liable for transactions made with the card, governed by the law on obligations and contracts, not the unproven terms and conditions of the credit card agreement. Legal interest on obligations. In the absence of an agreement on interest rates due to lack of consent to terms and conditions, the legal interest rates prescribed by law apply to the outstanding balance from the time of demand until full payment. This tale serves as a cautionary reminder to be vigilant about the financial instruments we use, especially those that come unsolicited. It underscores the importance of informed consent and the need for financial institutions to ensure their clients fully understand the agreements they enter into. This story is a simplified version of a real legal case. It aims to provide an overview and should not be considered legal advice. Legal outcomes can vary based on different factors. Always seek professional guidance for legal matters.